Good morning, sir. You're John Martin.
Yes, sir. Yes, ma'am.
And Mr. Martin is charged in cause number 25 DCCR 0583 with injury to a child, elderly, or disabled individual. And Mr. Burbank, what is the announcement?
I believe the state and I are looking for some CPS workers. So
I don't see that there's been an order for those yet.
There hasn't, Judge. I'll get one filed. I needed to talk to Mr. Burbank to see if he already has one. He does not, so I'll be sure.
Okay, yeah, let's get that done quick because it takes a while, it seems like, on some of those. I'll sign that order as soon as it comes through. Let's go ahead and just do a 60-day reset because obviously it'll take a little time once I sign that for those to come in, but hopefully they'll come
they
in.
may have them over on the civil side. Upstairs.
Okay, all right, yeah, if we can get
I'll
on
check
that way,
there, Judge,
that'd be
and
great.
If not, I'll reach out to Miss Adams. She
Okay.
usually gets them.
She is. Thank you. All right, Mr. Martin, stay in touch with Mr. Burbank. He'll let you know when you need to be back. You're free to go, sir. Yes, thank you. Ms. Holmes, you have TJ Landry. Good morning. How are you?
I'm gonna have to email the attachment.
Okay. Good morning, sir. Are you TJ Landry? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Landry, in cause number 24, DCCR 0165, you're charged with the state jail felony offense of theft from a person from December 9th of 2023. And how do you plead to that charge?
Yeah, show me no comment.
You either did it or you didn't do it. Are you guilty or not guilty? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak out loud, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
It looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And is there any restitution?
No, the shoes were recovered that day.
Okay. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Landry is not
No,
competent?
Your Honor.
And Ms. Malfino, with regard to waiving pre-sentence report, is there any issues with regard to history I need to?
No, Your Honor, it looks like there may be some misdemeanor contact, but he has no felony history. I have no objection.
All right, so what I'm going to do, Mr. Landry, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right, I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. In just a few minutes, probation's going to call you up to go over your paperwork. She's sitting at that desk right there, so watch for her to call your name, okay?
Yes, ma'am.
Good luck to you, sir. Yes.
Sorry to interrupt.
Hang on.
Just, since we're waiving the PSI, may I ask to request of the court that one, he be trespassed from Parkdale Mall, and that he not be allowed to have any contact with a Jalen Nixon or Reginald Guillory.
All right, so I'm going to order as a condition of your probation, Mr. Landry, that you are not allowed to go on the premises of Parkdale Mall. That'll be a part of your probation. Also, you are to have no contact or communication with Jalen Nixon and tell me the other name.
Reginald Guillory.
Reginald Guillory. So that means in person, y'all can't hang out, but it also means any other way. You can't send messages, you can't Snapchat or DM or anything like that. You go live your life, and whatever they do, they need to live theirs. Make sense? All right, you can have a seat. Thank you, Ms. Malfino. And then, Ms. Holmes, you have Edmund Latulis? Edmund A, I'm sorry, I do that every time. Oh, I don't see her, so,
We didn't report.
okay, I'll recall her as soon as she's ready.
Actually, she can take the right.
Mr. Lewis, are you still working on Deshauna Bass? Oh, okay, hold on, y'all can come on up. Okay, we're going on a lesser. And this is Mr. Coleman's on Deshauna Bass. Good morning, you're Deshauna Bass? And will she waive the formal reading of the indictment?
She does.
And Ms. Bass, in cause number 24 DCCR 2316, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from October 27th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bass is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for a period of 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation is going to call you up in a few minutes when she's ready to go over your paperwork. So she's at that desk right there, so be watching for her to call you up, okay? Good luck to you, ma'am. Thank you.
Thanks, Judge.
Thank you.
And your signature's not on that.
Yes, ma'am.
Yes, ma'am. It's like it doesn't matter if it's long or short. It's always the same. Mr. Rennick was just here.
Mr. Crenshaw went back there.
He's with his client, Judge.
That's why she's not asking. Trying to figure out on
Let's see, Ms. Holmes on Edmund A. Latulis. I'm ready on that. Good morning, ma'am. You're Edmund A. Latulis. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Latulis, in cause number 24, DCCR 2057, you're charged with the state jail felony offense of abandoning or endangering a child, and that is from June 14th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Speak up, please. And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $300 fine. You would be required to follow all of the rules and conditions of probation, including any referrals for any type of emotional support or counseling that you need. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation? Mr. Frazier, can you hold it down, please? That your plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Latulis is not
No,
competent?
Your Honor.
And
Judge,
do we need to get a PSI just so we know what all needs to, I think so too. All right, ma'am, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing. Thank you. Mr. Rennick, you have a sentencing on Ryan January?
Yes, Your Honor. Good morning.
Good morning, how are you?
Back
Yeah.
in Vegas last night.
Oh, nice. It's hard to feel sorry for you.
That's tough.
Party Saturday.
Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing.
Negative.
Negative. All right, sir, you're Ryan Eric January. Speak up, please. And Mr. January, in cause number 25 DCCR 0370, was previously in court, entered a plea of guilty to the third-degree felony the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have
State house.
Any additions or corrections?
nothing but
So I guess I had a question. I did not realize if we do this on all or if this, but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or,
We have.
I'm sorry. Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life, and so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you talk to probation, they'll let you know how to get started on that, and you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir. Numbered it. Mm-hmm. This, Donald Owens, where is
It's
it?
on the trial docket, Joe. It's on Kelly.
Oh, that's today's. I'm sorry. That's why. Mr. Kelly? Donald Owens?
Morning.
Good morning. Good morning, sir. You're Donald Owens Jr. And Mr. Kelly, will your client waive the formal reading of the indictment? Sorry, it's going a little slow. It's stopped spinning now. Oh, there, shut up. All right. Mr. Owens, in cause number 24, DCCR 1192, you're charged with the second-degree felony offense of sexual assault of a child from March 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because they you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? And do you fully understand them? And my understanding is there is no plea bargain. This is just open to the court. Is that correct?
That's correct.
And that there is, in addition, not a waiver of the right to appeal because of that as well,
That's
correct?
yes, correct.
And is that your understanding? That I want to make sure you understand, Mr. Owens, obviously you know your case is set for trial to begin with jury selection this afternoon. You have every right to have that jury determine if you're guilty and what your punishment is. If we go forward this way, you're pleading guilty and you're leaving your punishment up to me. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Mr. Owens is not
There's
competent?
not.
In addition to that, Mr. Owens, you do understand that as a condition of your plea in this case, that you will be required to register as a sex offender. And I have that document that you've signed with Mr. Kelly, and y'all went over that this morning, and you understand it. All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So for sentencing, since it's unagreed, do you guys anticipate lengthy hearings, witnesses? What type of time frame do we
Expect
need?
us to call witnesses, Your Honor.
Okay, any more than an hour's worth? Something we could do at the end of a docket? Or do y'all anticipate more
I
than
don't
that?
anticipate any more than that, Judge. We may have one witness,
Okay,
but I don't want to confine us to that. If it goes over, we only have, I only expect.
no,
one
I mean, I
witness.
want that, well, that's what I want to
Yes.
figure out, is if you anticipate that it could be longer than that, then I can set it on a date other than a Monday, when we don't have a trial or something like that. But if you think y'all can get it in at the end of a docket from 11 to 12 or
If the court can consider not putting it on a Monday, that's what we would ask for.
okay, all right, we'll take a look at appropriate date for that and let y'all know that court date. Obviously, anything you think is important for me to know, get that information to Mr. Kelly, and then I will look at all of that and listen to everything when we come back. All right, don't forget to stop and talk to probation. Thank you.
Your Honor.
Thank you, Judge.
Mr. Crenshaw, you have Timoteo Castaneda.
Yes, Your Honor.
Good morning.
Good morning. Good to see you.
You too.
Sorry
That's all right.
about the case.
Good morning, sir. You're Timoteo Castaneda?
Yes, Mom.
And in 25 DCCR 0360, Mr. Castaneda is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, if we could come back, we're very close. We're trying to get a probation offer, and once we get that, this will be resolved. We're just not quite there just yet. I think we've only been here once.
Well, it looks like you were hired in May, so this will be the last reset on this
Okay,
case. So, Mr. Castaneda, make sure you stay in touch with Mr. Crenshaw so that any information he gets from Mr. Hoffpower, you guys can go over and we'll get an announcement at that next court date. All right, thank you. Catherine Jordan, Mr. Crenshaw.
Yes, Your Honor. This is going to be a plea. We need Mr. Coleman. I don't believe he's here today.
Okay,
If we could just come back on a standard reset. She was trying to get the full restitution, and the good news is she has that. And
so I can set it on an actual plea docket and y'all will get it taken care of
Yes.
on a plea docket?
yes.
Okay, then I will reset it to a plea docket. Obviously, once it's on that plea docket, I expect it to enter a plea on that day. If anything changes before then, just let me know.
We sure will.
Stay in touch with Mr. Crenshaw. He'll let you know when you need to be back and we'll take care of that. All right, thank you. Let's see, and you have a sentencing on Sidney Lewis, Mr. Crenshaw?
Yes, Your Honor. We're ready for sentencing. The only thing that I would add, Judge, is that we now have an agreed restitution figure for
That's
the court.
my question.
Yes,
What is it?
60,000.
Okay. All right, ma'am, you are Sidney Lewis? And Ms. Lewis was previously here in cause number 24 DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense has, Your Honor, we have no objections.
Yes, Judge.
And Mr. Smith, any objections or corrections? No. All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two, and I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you, Judge.
And then you've got a David Melanson, Mr. Crenshaw.
Yes, sir.
Good morning, sir. You're David Melanson? And this is 24 DCCR 1186. Mr. Melanson is charged with assault on a family member with previous convictions. And is there an announcement? It looks like you were just hired on this one.
I was, Judge. We're actually on the next setting, I think going to, the state's gonna subpoena the complaining witness.
Okay.
And, I think we'll have a resolution on that date.
Okay.
And I have not heard from her since June of 2024, Judge, but if the court would allow
Sure.
me maybe 30 days to send a subpoena.
Yeah.
And Mr. Crenshaw has also presented me with information that he believes there's a non-prosecution affidavit, so we're both gonna try to get our hands on that.
Okay, so I'll just do a normal reset to give y'all time to get that taken care of. Make sure you stay in touch with Mr. Crenshaw. He'll let you know when you need to be back. All right, thank you. See, have we heard from Mr. Adams? Or Mr. Kimler? And my clerk and I talking to everyone and figuring out what's going on. Here's what I think we figured out. We know what you're doing. So you're getting a patch from Johnny's or from Al Reed on the same day and going in with a clean one to get tested. Why are you getting patches at two places?
To explain to her what we talked about in private.
I got two patches because I thought Al Reed patch was for Al Reed and Johnny's was for you.
He's on bond with Al Reed.
Yeah.
So did Al Reed tell you you had to have a patch?
Yes, ma'am. They came, gave me a patch before I was even released.
So you're not showing up anywhere with two patches on though. So if you have two patches, if you're getting two patches, you should have two patches on, right? How many patches do you have right now?
One,
Okay, so whose do you have on?
Al Reed.
So what about Johnny's?
I'll stop getting Johnny's because Al Reed told me I didn't have to get them anymore.
He didn't seem to indicate that the quality of the patch from Johnny's is different than the quality of the patch from Al Reed's, and the difficulties he was experiencing with the patch from Johnny's was because it was an inferior quality patch and came off.
So when did you get that patch? Do we know? Let me see.
I get it changed on the 7th, so. 24th, 25th.
So you got a patch put on the 25th from Johnny's also.
No, I paid them for an old patch on the 25th.
They specifically put a date down that says, these are the dates that he has come into our office and have patches put on. And the 25th of September is one of those dates for Johnny's.
Okay.
Did they put one on or not on the 25th of Johnny's? I understand it says that, Your Honor. I don't know that they actually did that. That's my point.
Well, they've got receipts, they've sent receipts, we've got serial numbers, we've got all of that information now.
Without them available for cross-examination, I don't know if they did or not, is my point, when they actually put one on.
I'll take a drug test. I don't do any drugs, man.
Well, I guess I don't understand, Mr. Mack. You've tested negative, I get in court, but I feel like there is something going on that doesn't make sense. And I feel like you're playing games.
Your Honor, in all due respect, it may not be him, it may be Johnny's. That's my point. I mean, the assumption seems to be it's the defendant's fault. And without having them available, I'm not conceding that there may be something, the problem may reside with Johnny's and not the defendant. I'm not making an allegation of that, but that needs to be ruled out. Because he doesn't seem to be having problems with Al Reed doing the drug test.
Well, there haven't been issues with Johnny's other than some untestable patches that came in untestable.
That's my point. The quality of the patch itself from Johnny's is probably.
I don't understand why he got two patches on the same day from two different places.
I don't know that Johnny's actually put a patch on. He paid them on the 25th. He went in and made a, They're telling him he owes them money, so he's going to.
Right, you're all caught up. They've already said he's all caught up. But they specifically said they put a patch on and they're willing to. And they went back and checked serial numbers and sent us this information. So
I guess I don't understand why Al Reed's not having the same or similar problems with him.
because he just started with Al Reed and he's doing both and there's something going on. And I'm tired. I'm tired. I mean,
Okay.
I'm just tired of dealing with it.
I am too, Your Honor. It seems like I'm spending more time with this case with the drug patch as opposed to the case itself.
I'm spending more time with the drug patch. Ms. Werner spent more time with this. And the only way here's where I am, is the only way I know to make sure that there's not games being played is to put him in jail because I feel like he's playing games. But, I mean, you've got a patch on. I don't understand.
You could just try the case, Your Honor. It would be the solution if you could get it tried.
Well, it's not put it on the trial docket. It is.
I think it was.
Well, I mean, we'll get it tried on the trial date.
It's Mr. Coleman's case. I believe it was set for trial a week or two ago, Your Honor.
Wasn't reached.
Yes, and it didn't get reached.
Okay. Yeah.
I think it was numbered.
Oh, okay, gotcha. Here's what I want. I want a hair follicle test done at Mr. Mack's expense
Where at?
today at, I think Beaumont Occupational still does that.
Oh, my, okay.
I'm pretty sure. Can you double check?
I'll see. I know, I'm pretty sure Quest probably doesn't.
It really doesn't matter to me, other than I don't want it done through a bondsman. I don't want it done through Johnny's. I want it done through either Quest or Beaumont Occupational or one of those places. I want it done today.
Yes, ma'am.
I want get proof that you've done that, and then I think it takes a few days to get those results, and I want those results immediately. And, yes,
You understand what you need to do?
You don't understand, but
Okay.
I don't, just want to have the funds. Because I just recently had a baby and
you're gonna get a hair follicle test. Figure it
Sell
out.
some plasma.
Figure it out. All right? You have 24 hours to get it done.
All right.
Okay.
Thank you. Thank you, Judge.
Go sell some. See, Mr. Adams, you've got Sammy Morris.
good morning, good morning.
Good morning.
Mr. Marks.
Good morning, sir. You're Sammy Morris. And cause number 25 DCCR 0242. Mr. Morris is charged with unlawful possession of a firearm by a felon. And what is the announcement?
My announcement, Judge, I'm requesting only one week. Said he's coming to my office this Friday at 4 o'clock to look at his discovery.
Okay.
It'll be Friday, 4 o'clock.
Any issues?
No, Your Honor.
All right, so I'll just do one normal reset. Mr. Morris, make sure you take care of everything you're supposed to. Visit with Mr. Adams over, I'll look at all the evidence, discovery, whatever the offer is, and let's get an announcement at that next court date, okay? You're free to go. And then you have Sandrea Stevens, it's the sentencing.
Yes.
Come on up.
Good morning, is it Sandrea?
See Andrea.
See Andrea, stand up, please. See Andrea Stevens, and Ms. Stevens, you were previously here in cause number 24, DCCR 2310, entered a plea of guilty to the third-degree felony of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes.
What is the status of the driving while intoxicated? I don't see that there's one pending, and this whole offense had to do with that as well, which gives me some concern.
I don't think she was charged with it. No, as I'm aware.
I was only charged with evading my vehicle. Cause I even called up the Jefferson County to make sure that that was the only thing I was charged with.
I mean, that's weird, because it says she even explained that she was drinking, and I don't know.
Right, and it's not even noted in the probable cause.
I know.
You know, the section where they
Right.
list the charges, even if there were in two separate courts, but I will be happy to look into that what we like.
I guess I just want to make sure, I mean, if something's not pending, if it's coming later, so that we're kind of aware of that, but, okay, so what I'm going to do then, no additions or corrections? All right, ma'am, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to prison for anywhere between 2 years and up to 10 years. Do you understand?
Judge, would the court consider, just based on what we've just discussed, maybe an interlock for some period of time?
So it looks like there is some even self-reporting of some issues with drugs and with marijuana and alcohol. And so I think to be safe based on the nature of that, I am going to do that. I am going to order that as a condition of your probation, you have an interlock device on any vehicle that you have. Mr. Adams in probation can explain what that is. Okay, so you have to have that at least for some amount of time. Maybe not the whole probation, but we want to make sure that you are refraining from using alcohol before you drive and anything like that. Obviously, that goes for marijuana as well. You're going to have a regular drug test if you test positive for marijuana or anything that contains marijuana. So that includes anything. Don't come in and say, well, it was Delta this or whatever that I bought and it's supposed to be legal. I don't care if it's legal or not. I don't want it in your system. Okay. And so if you do everything properly, then we shouldn't have any issues. I mean, because this shows you admitted that you smoke 6 a day. Is that correct? Daily use of marijuana?
Oh, yes, ma'am. I'll do it now. Yeah.
When's the last time you used?
What's today, Monday, Saturday?
Saturday.
Yes, ma'am. And that was just,
Just one, the Saturday before you're coming in on a felony. So I'm going to order that as a condition of your probation, you enter and successfully complete the JCDI program. All right, that is an intensive outpatient treatment program. If you do not successfully complete that and stop using marijuana altogether, you will be back in here and you will be looking at going to prison. So it is time that you change that part of your life. We're going to give you those tools to do it. Well, this will help you. That's what this is for, all right? But you have to participate and you have to you get the tools and use them. They can only do so much. Obviously, you're going to test positive when we know you will, at least for some amount of time, but you're going to get tested where they also get the amount that is in your system. And if it is not going down and getting to nothing within the next 30 days or so, that means you're still using, you're going to be right back in here before you really ever get started. That's how important this is. So take advantage of it, get started on the JCDI. Probation will go over how you get started on that. And make that change in your life so you can do this probation and everything. Does that make sense? So you have 24 hours to get the auto ignition interlock device on your vehicle. So you cannot drive any vehicle that does not have that device on it, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom, and probation will go over, call you up and go over your paperwork when she's ready, okay? All right, good luck to you.
Thank you. All right.
In this courtroom proceeding, John Martin appears before Judge Raquel West, charged under cause number 25 DCCR 0583 with injury to a child, elderly, or disabled individual, a felony-level allegation carrying significant legal consequences. The charge alone signals serious potential sentencing exposure, depending on the severity of the alleged harm and prior criminal history. However, rather than addressing guilt, innocence, or a finalized plea deal, the focus of this hearing centers on procedural preparation. Defense counsel and the state indicate that Child Protective Services, CPS, records are necessary. These records can be critical in injury-related cases, especially when minors are involved. CPS documentation may contain investigative findings, prior reports, medical assessments, or witness statements that could influence plea negotiations or trial strategy. Judge West immediately recognizes the procedural gap. No formal order has yet been submitted to obtain those records. She instructs counsel to act quickly, noting that CPS responses can take time. The court resets the matter for 60 days, a strategic timeline that allows record retrieval while preserving judicial efficiency. Why does this matter? First, CPS records can significantly affect plea deal negotiations. If records support the prosecution's claims, the state may pursue harsher sentencing. If they introduce doubt or mitigating context, defense leverage increases. Second, in cases involving injury to a child, sentencing stakes are high. Depending on jurisdiction and facts, penalties can include substantial prison time, probation restrictions, mandatory counseling, or registration requirements. A delayed hearing does not reduce the seriousness of the charge, it simply ensures due process. Third, the judge's measured handling reinforces procedural fairness. Rather than rushing toward sentencing or a final ruling, the court ensures all relevant documentation is available. This hearing represents a critical pause, not a resolution. The absence of a confirmed plea deal suggests negotiations may still be ongoing. The 60-day reset keeps uncertainty alive while signaling that the next appearance could carry much heavier consequences. In high-stakes felony cases like this, preparation often determines outcome.